Welcome back to another episode of Grizzly True Crime. My name is Gisela K, and today we're going to look at the latest news in the Delphi case, and then I'm going to read you the documents that complements this news. I originally thought I'm just going to read you the documents, but I think that a summary, just using layman's terms, is going to be the very best before I read the documents. So I will put timestamps and everything below, so if you just want to skip to the part where I'm reading the documents, feel free to do so. So let's get into this news here. Richard Allen's defense team requests additional money for his case. If you haven't followed anything with the Delphi case, I do have a playlist for you, which is also linked below for you. I'm sure you can catch up there in no time. A lot of the coverage that I had was, of course, before they arrested this man called Richard Allen, which we believe to be Bridge Guy based on everything they're saying. But I know that this case could still have, as Dakota said, many tentacles. We're yet to see if anyone else will get arrested or if he was really a lone wolf. And there's just a lot that I'm sure will still come out from this case. And I will keep you posted on that. So make sure if you do want to follow Delphi case coverage and other cases I'm covering, subscribe, hit the bell, make sure you like the video and share as well. That will be very, very helpful. So let's have a look at this news in layman's terms before I read the documents. Carroll County. On Thursday, the defense attorneys representing Richard Rick Allen filed a motion with the court requesting additional funding. Allen is currently charged with 2 counts of murder in connection with the deaths of Libby German and Abby Williams in February 2017. In court filings, they asked the judge to approve the addition of an investigator to help sort through dozens of tips. It is possible that Carroll County taxpayers will be on the hook for the funds needed to cover the initial costs of this case. In their most recent prior move, the defense attorneys released a public statement declaring the innocence of Allen. If you missed that, that's all in the playlist as well. Part of their statement included, Rick is a 50-year-old man who has never been arrested nor accused of any crime in his entire life, Allen's lawyers said. He is innocent and completely confused as to why he has been charged with these crimes. I mean, again, I'm going to say, in case you missed it, they are doing excellent jobs as public defenders. They are, of course, saying the man is innocent. That's pretty much that's their job. That's what they're going to do. Our client is innocent. He's completely confused as to why he's been charged with these crimes. And, of course, just, planting a seed of doubt in the public's mind. So I think they're right on track to doing exactly what they should do before the trial begins. On December the 2nd, Gull issued a gag order. We also looked at that previously, preventing those involved in the case from discussing details publicly. WRTV has requested a copy of the documentation, but it's yet to receive it. So we got that documentation, and I'm about to read it to you. So are you ready? Let's deep dive it. Before I do, though, let's just quickly have a look at the public records. This is on public.courts.in.gov, and you can just search the case yourself if you wanted to. State of Indiana versus Richard M. Allen. I often check here for updates to see what's happening, and yeah, I could see something was happening before these documents even came out. So the type, they say, of course, Carroll Circuit Court, MR Murder, filed 10/28/2022, and lower trial court case is what it says there. Richard M. Allen versus the state of Indiana, there is the charge, 3542 1-1, and in brackets 2. I think the reason they've chosen to charge him with precisely that is because it's going to be much easier to find him guilty of that if he is the guy that is not only seen on Libby German's phone, but also if they can prove the audio is him saying, guys down the hill. And then we've, of course, got that unspent round from his gun, according to what they've said, right, found between victim 1 and 2's bodies. Their bodies were found on February 14th, 2017. So I just think that the reason they've chosen to go with that, because I see there's still a lot of questions about that, why not just a normal murder charge, if I can call it that, and why the 2, is because the 2 would say that the victims were killed in the act of something else, and that something else could be kidnapping. And kidnapping will be really easy to prove and find him guilty of if he, as I say, is the guy walking towards them, the guy dressed like that, he said he was there that day on the bridge, he said he was wearing that, and if he said guys down the hill, then you see what I mean. Also, before I forget, I wanted to mention, when we went over the probable cause affidavit, we also went over it with Cop Facts, which is Perry Freeman, so please check that episode out if you missed it as well. It was very interesting to get his insight on the case. When they described, there were 3 witnesses describing the car that they'd seen parked at the old CPS building. One of them mentioned was a purple PT Cruiser, which is quite specific. Now, what's interesting, of course, is that it seems like Tony Klein's mother has a purple PT Cruiser. So if that's true, then again, it brings up the questions of, are the Kleins involved at all? So that's going to be interesting to see what unfolds. Okay, so let's just have a look at if there's any updates here. So what you can do, if you go to the site, you can see the charges as well. You can see the whole timeline of when everything was filed and all of that. And what I could see happening, I'm just quickly going to scroll to the bottom. So what I could see here is, of course, we knew about the dates for, the pre-trial conference and the hearing and everything. And it seemed like there was quite a bit being cancelled. You see here. So I was like, why are things being cancelled and what's happening? But it's because, of course, everything stops until now they get the funding for these defenders, from what I understand. So they say motion filed, that was 12/8/2022, motion for leave to proceed ex parte, Richard M. Allen. And then 1/13/2023, cancelled pre-trial conference, 1/13/2023, hearing, and 2/17/2023, hearing as well. So those 2 hearings are still happening there, the newer one being the 13th of January, 2023. And I believe that is about a bond hearing, because they want a more reasonable bond to be set, and also for this gag order hearing. And then they say 03/20/2023 jury trial. So you can see they're rescheduled, cancelled, everything cancelled. And so we'll see what happens from there. The first thing that has to happen is this hearing on 1/13/2023. And as we said, it would actually be quite unlikely if the trial started in March of 2023, because usually these types of things take a lot more time. There are a lot of delays. There will be possibly, he might, go the whole have to prove the mental competency and all of that. So we'll just see how it goes. As I say, in all these cases, if you really want justice for the victims, you gotta have patience. Things do not happen like a TV show. You just have to have patience and let everything work itself out in now the next phase of the investigation, which is this legal process. We want Richard Allen to have a fair trial so that, of course, there can be justice for the victims, and so that everybody's sure that they've got the right guy, that this is the guy who committed the crimes. At this point, innocent till proven guilty in a court of law, so we have to wait for all that to happen. Okay, now let me read you the documents. There's 2 documents I want to show you today, just so that we have it on file as well. So, State of Indiana versus Richard M. Allen. Motion for leave to proceed ex parte on defendant's motion for public funding for cost of representation, including expert fees and expenses. Comes now, defendant by counsel, and respectfully requests this court to 1. Permit the defendant to file an ex parte motion for public funding for cost of representation, including expert fees and expenses under seal. And 2. Conduct ex parte hearings upon that motion. And 3. Order the court reporter and all other court personnel to maintain all pleadings and hearings concerning the defendant's application for appointment of experts confidential, and not discuss or disclose to any person, including the special prosecutor or any of his agents. In support of this motion, the defendant asserts the following. 1. The defendant is charged with the crime of murder. 2. The defendant is without funds and cannot afford the costs of representation, including expert fees and expenses, including transcripts and investigators, necessary to assure him an adequate defense and a fair trial in this matter. 3. The defendant is entitled to proceedings on his application for cost of representation, including expert fees and expenses under AKE versus Oklahoma, and there's a whole number there, right? 4. Indiana's practice of providing indigent criminal defendants with the means to defend themselves long predates such requirements as exist under federal constitution. 5. Carroll County's public defender is eligible for reimbursement if its comprehensive plan complies with the Indiana Public Defenders Commission standards. Standard N is applicable to this request, and a copy of the full standards is attached. It, in part, recommends an ex parte application and hearing. 6. A trial court may, upon a showing of good cause, permit an ex parte request for funds for assistance. Here they give an example, Stevens versus State. Further, the Indiana Supreme Court amended Criminal Rule 24 effective January 1st, 2001 to specifically authorize ex parte hearings for funds applications in capital cases. There is no reason why ex parte hearings in non-capital cases should be considered improper, especially in a murder case. 7. The funding of representation, including expert fees and expenses, including transcript fees and investigator costs, in this case, is necessary in order for the defendant to present an adequate defense and be afforded a fair trial, a showing which defendant is prepared to make in an ex parte hearing. 8. To effectively show the need for assistance and enable this court to make informed decisions, defense counsel must reveal to the court their theory of defense, attorney-client confidences, work product material, and other privileged information. 9. Denial of this motion would force the defendant to make a public filing and have an adversarial hearing on the application for public funding of representation, investigative, expert, and other services necessary to present an adequate defense. Forcing the defendant to make their request for funds in a public, adversarial hearing would restrict their ability to make a detailed showing of need and would deprive this court of information necessary to make its decisions regarding expenditure of public funds. 10. An adversarial hearing would violate the provisions of Indiana Trial Rule 26b-4, which is based on the work product privilege and provides that counsel need not disclose the names and opinions of experts unless and until the defense decides that these experts will be called as witnesses at trial. More examples there, and as noted above, Standard N recommends ex parte proceedings. 11. An individual with sufficient funds available for the costs of representation, including expert fees and expenses, would be able to retain counsel and pay for expert fees and expenses and would not be required to disclose the names of experts used for consultation and investigation unless and until it was determined that these experts would be called as witnesses in trial. 12. In regard to expert fees, it is impossible to state at this point in the investigation whether the expert witnesses defendant seeks will be called as witnesses at trial. This is a decision that can be made only after these experts conducted tests, evaluations, and investigation. 13. Granting a wealthy person the protection afforded by the work product privilege while denying an indigent person the same protection solely because of their indigency would violate the indigent person's equal protection as guaranteed by the 14th Amendment to the United States Constitution and Article 1, Section 23 of the Indiana Constitution. Here they give another example. The Indiana Court of Appeals rejected an equal protection challenge to the denial of ex parte funds requests, finding a rational basis for requiring a specific showing of need for expert assistance. However, the Beauchamp Court did not address the equal protection implications of requiring an indigent person to have to make the showing in open court, revealing work product and other information to the state. The defendant does not object to the requirement of making a specific showing of need for expert, transcript fees, and investigation expenditures, but rather objects to any requirement they make the showing in open court, revealing work product and otherwise protected information to the state. 15. The defendant has no voice in the selection of expert witnesses employed by the state or in the selection of law enforcement officials who assist the prosecuting attorney in preparing the state's case against them. To allow the state to have a voice in preparation of the defense case would violate principles of fundamental fairness. 16. The denial of this motion would violate the defendant's rights to fundamental fairness, to the effective assistance to counsel, to present evidence, to be free from compulsory self-incrimination, to confront witnesses, to compulsory process, and to equal protection of the laws as guaranteed by the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as by Article 1, Sections 12, 13, 14, 19, 22 of the Indiana Constitution. 17. The ex parte motion for public funding for cost of representation, including expert fees and expenses, would be filed under seal and would not be served upon the prosecuting attorney. This motion would be sealed and preserved as part of the court's record, in this case for future appellate review, should such review be necessary. 18. The hearing on defendant's ex parte motion for public funding for cost of representation, including expert fees and expenses, would be recorded by the court reporter, transcribed and sealed for purposes of appellate review, should such be necessary. Wherefore the defendant, by counsel, respectfully requests this court conduct the proceedings on the defendant's application for public funding, ex parte and on camera, without the presence or participation of the prosecuting attorney or any of his agents, and for all other relief just and proper in the premises. Respectfully submitted, Andrew Baldwin and Bradley A. Rossi. Okay, and then in the follow-up document, it's State of Indiana versus Richard M. Allen. They granted the order. Order granting leave to proceed ex parte and on a sealed record with regard to applications for cost of representation, including expert fees and expenses. Comes now defendant by counsel upon motion of defendant for leave to proceed ex parte with regards to any applications for public funding for cost of representation, including expert fees and expenses, and the court having examined the same and being duly advised in the premises, now finds the same should be granted with regard to all requests for funds for such assistance necessary to prepare the defense of this case. Counsel for defendant shall be allowed to file written motions for such assistance without serving a copy on the prosecutor. All such motions shall bear the following legend, preceding and separated from the style of the motion: ex parte pleading, to be placed under seal, and the clerk shall ensure that these filings are not accessible by the prosecutor. If a hearing is necessary to consider the motion, it shall be conducted in chambers or via Zoom or WebEx. The court reporter will take down the proceeding, but any transcript shall be made available only to the defense counsel and the court until further order of the court. The original transcript shall be placed under seal. The clerk shall not permit any person other than the court and counsel for defendant to examine such motions, orders, and transcripts regarding such application for funds. These motions shall be segregated for the remainder of the file in the case. The clerk, the sheriff, and any deputies from his office, the court reporter, and the Carroll County Public Defender Agency, and any agents are hereby restrained under penalty of contempt from disclosing to anyone the nature of any motion or order relating thereto, any testimony or colloquy adduced at any hearing on such motions, the text of any transcript, or any information disclosed in such proceedings. Furthermore, all county personnel who are necessary for the processing of the paperwork associated with the ex parte request for funds and disbursement of those funds are hereby ordered under penalty of contempt that should they become aware of any violation of this order, they are to immediately notify this court of such violation. So I can see this one isn't signed yet, but these are the latest documents in this case. Over here, I have a picture of that purple PT Cruiser, which apparently Tony Klein's mother owned at the time of the murder. So that is very interesting. If you want to hear more about that, might I suggest a video for you, which is from the Captain Howdy. I'm going to link that below for you as well. Check that out, because that's starting to make sense to me about the probable cause affidavit. Because when I saw the probable cause affidavit for the first time, I thought, well, why were they trying to keep it sealed? Like, what was it? Because it doesn't seem like there's any mention of other people. But if it's about the cars, and they're mentioning these, a smart car, a purple PT Cruiser, and a Ford Focus type car, right? Wow. If it's the PT Cruiser, that's a bit of a giveaway that they could be a link to the Kleins. Well, now that becomes very interesting. So please check out the video called The Delphi Murders. There is always a bigger fish by the Captain Howdy. Thank you so much for watching. I really appreciate it. If you like the way that I present true crime, if you like document readouts and things like that, of course I do many other things, like the video, share, #Delphi, #Justice for Abby and Libby, #Grizzly True Crime. If you can, find me on Twitter. I am at Grizzly Gisela on Twitter, and I'm very active on that social media platform, much more than anywhere else. If you haven't yet, please subscribe, hit the bell, become part of this wonderful community of Grizzlies. So just know if you are subscribed, you're a Grizzly. And I will see you again very soon. The reason you hit the bell is, of course, not for me. That's for you, so that you know when I'm next going live or doing a premiere or, uploading something for you. I really appreciate you being here. Thank you so much, and I will see you in the next one. Stay safe.